From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. Let's take a few listener letters, starting with replies to our conversation on the bill to ban stock trading by members of Congress and also other federal officials. And Jack says, I understand the arguments you all gave against the bill, which for the most part is that Americans who go forward to do civil service should not be penalized. He suggests that's not what the attitude was during the early years of the Republic. He says, read Hamilton, and you see that he felt his personal resources could wait while he helped build and defend our new republic. And he finishes by saying, look at what Pelosi and Biden had when they entered Congress against what they are worth today, and tell me that there is not a problem. And Kim, I don't know, my reply to that is that I don't dispute that there is a problem, or at the very least, a perception problem with this trading. I guess I go back to the Thomas Sowell quote that I think I use, which is that there are no solutions, only trade-offs. And I'm not sure the trade-offs are worth it. If we devise a rule that anybody coming into public office has to divest everything, put it in a blind trust, if we make the rules so onerous that when we're in the middle of a pandemic, we don't have pharmaceutical executives who are willing to do what it takes to spend 6 months in a government post or 9 months in a government post, I think that is a trade-off that I might not be willing to make.
Yeah, and I do understand people's frustration when they look and they see politicians who appear to have gained a lot of wealth while in office. Although I would sometimes note that those perceptions are a little misleading. For instance, if you look at Joe Biden, yes, Joe and Jill Biden are quite wealthy these days. And people say, well, how does that even happen? Joe Biden has spent his entire life in public service, essentially, other than a few years as a stint as a lawyer before he was elected at a very young age to Congress. But if you look into their finances, and Forbes had a very good article on this, for most of their lives, most of their working lives, they brought in about $230,000 a year based on his government salary and her government salary and some teaching gigs. It really wasn't until 2017 when Joe Biden left the vice presidency that they really cashed in. They had 1 year in 2017, he made $11 million in speaking engagements and book payments from a memoir he'd written. Altogether, they put together like $17 million over 3 years. And that does account for the vast majority of the money that they've earned over their lifetime. And so what you have often is a lot of people who come to office, and because of the sort of fame and glory that they attain, they're standing when they're in office. When they leave, they are very much able to kind of cash in on that public persona. But not necessarily, there are quite strict rules about what you can earn and how while you're in government. On the Hamilton point, I get it, although I also think that society has changed somewhat. As we well know, a lot of the people who were very dedicated public servants in the beginning of our republic were wealthy landowners, people who had the means to take some time off and devote themselves to the service of the country. It's why you don't hear as much about farmers or other regular laborers who were in Congress in the beginning, because they couldn't. Their families would starve. I think that situation still generally applies here, and I'd still like to see more average folks taking some time and bringing the knowledge that they have from professions into Washington, rather than solely having legions of highly paid lawyers and businessmen as the only people who are able to come and do public service.
Kim, I think you make a great point that fame is worth a lot, and I would add Bernie Sanders to that list. There's a NBC story from 2019. Bernie Sanders' income popped to over $1 million after his best-selling book about the 2016 presidential race. And I mean, that's income gain that is not related to any sort of stock trading or stock picking. I'll go to a second letter here. Dan says, a solution to the stock ownership and trading issues discussed could be to shorten the 45-day reporting period required by the Stock Act to 2 days. He says it's his understanding that the SEC requires corporate insiders to report trades within 2 days, and those trades are immediately made public. Monet, I think that's a good point. Another one I would add is that the last time I checked some of these stock disclosures, many of them were in paper PDFs, which is not the most user-friendly way to go looking for this information, and maybe deliberately so. Maybe there's a reason that those people file them as paper PDFs. But if we required a searchable electronic filing, that could help too. And if we post them within 2 days, I think you would get a lot more attention on these trades.
Yeah, I'm not against that. I think one of the ideas behind the Stock Act was to make the requirements for these office holders pretty similar to the requirements that already exist for corporate executives. And so I don't necessarily see any problem in shorting the time frame required for them to report. But I don't think that it would really make any difference to what is at the heart of this question, which is the appearance of impropriety when you have people sitting on committees getting sometimes confidential testimony from people who are involved in a very sensitive area that's going to have an economic impact. And I'm thinking specifically about the beginning of COVID. There were certain Congress people who were briefed on the impact that it might have by researchers long before the public was aware that this is going to be something that could potentially ripple throughout the entire economy. So whether these office holders are reporting trades 2 days after or 4 days after, I think ultimately it's going to be our journalists and others able to sort of trace some reasonable connection between private information they received and then trades that they made. And that could be a trade that's made even a week after they received that information, as long as it was still confidential at the time. Basically, the Stock Act, I think, gets pretty close to putting the kind of reasonable restriction we would want to have on their ability to trade based on non-public information. And if people want to continue to fine-tune it, that's fine by me.
Finally, a few listeners have pushed back against our analysis of the debate over the Supreme Court's legitimacy. Ray says we have ignored the key issue, which is the Senate's decision to not put Garland forward and delay almost a year so that Republicans could put their own candidate forward. And again, when they rushed Justice Amy Coney Barrett's confirmation at the end of Trump's term, he says, I'm a Republican and approve of both moves, but to not recognize these actions as the left's reason for complaining about the legitimacy of the court seems disingenuous. And Rob adds that he fears the pure ugliness around the confirmation process can't help but make the human beings bitter toward the other side, and this has to play into their judgment. Kim, what do you make of those replies on the court's legitimacy?
If we failed to note McConnell's tactics, that was not on purpose, because certainly I agree that that plays into Democratic bitterness. And I think maybe if I did fail to mention it, it's because I guess in my mind, all of these actions that Republicans and Democrats have engaged in sort of cancel each other out. Meaning, if you look at Mitch McConnell's decision to hold off on confirming Merrick Garland, that was at the end of a long line of kind of mutual lowering of the bar on both sides, which began with Harry Reid and Democrats deciding that they would eliminate the filibuster for appellate court nominees because they were unhappy that Republicans were filibustering, and then Republicans responding by eliminating the filibuster for Supreme Court nominees because they were unhappy with Democratic filibusters of Trump nominees. And you just keep going on. This is kind of the way of Washington, unfortunately. And I agree with the last listener, too, that this is now just become so bitter. If you look at the long history of Supreme Court nominations, for most of 200 years, they were relatively quick. They were relatively bipartisan because they generally operated on the assumption that a president had a right to nominate a qualified jurist, and barring some massive ethical issue or a nominee who outright rejected our standing laws, that they were going to be confirmed. And that was pretty much the case. You start to see things fall apart a little bit in the 60s and 70s. In particular, some of Nixon's nominations became quite contentious. But the real moment that this really changed was 1987 and Robert Bork. And Democrats decided that really kind of for the first time in history, they were going to make this not about legal qualifications. No one could have argued that Bork was qualified. He sat on the D.C. Circuit. He'd been Solicitor General. But that rather they were going to make it about his opinions and his legal readings and his method of jurisprudence. And they didn't like any of those and the way he thought about the law. So it wasn't that he wasn't qualified. They just didn't like him. And it's been a complete downward spiral since then, coming straight up through the Brett Kavanaugh circus that we witnessed. So both sides have played a part here. I totally agree with that. And somehow the only fix for this and the way to sort of restore some legitimacy is everybody's going to have to act a little bit more grown up, both in the confirmation process, but also in terms of the language that they use surrounding the court. We cannot have prominent elected public officials throwing shade on justices all the time. It's really, really corrosive, and it's just something that our entire class of politicians really needs to clean up its act on.
I agree almost entirely with you here, Kim, that the blocking of Garland was sure a breaking of the norm, but it's a long line of breaking of norms. Gets a little Hatfields and McCoys after a while. Another data point I would throw in is the blocking of the Republican nominee Miguel Estrada for the D.C. Circuit Court of Appeals. It was filibustered by Democrats. Republicans tried to break that filibuster 7 times and failed to do so, and then he finally withdrew his candidacy. I mean, we are getting to maybe a break point here of what happens now if you have a president and a Senate controlled by different parties. Are you going to have Supreme Court vacancies for years on a time until finally the president picks up the Senate or the Senate's party picks up the presidency? And what would that do to the operations of the court? But the other thing that I would add is just that if we want to depolarize and lower the temperature on these Supreme Court confirmations, I find it hard not to agree with the current Supreme Court's approach of getting out of the business of dictating hot button issues for a vast country of 330 million people. And if the background noise at every Supreme Court confirmation is no longer going to be Roe v. Wade, it will be interesting, Monet, to see how that changes the conversation in the Senate.
I think that that's going to take a very long time to have any effect on the political climate around the court. With due respect, I completely agree that I think it's a good thing that the Roberts Court is clearly saying that they want to return some of these hot button issues to state legislatures, to Congress, but certainly the impact in the short term of overturning Roe versus Wade will obviously be to turn up the temperature on these fights as opposed to reduce it, because people are thinking if they were willing to overturn that precedent, what else might they be willing to do? And so the stakes for these appointments are only going to increase. I want to go back to one sort of factual point regarding what one of the listeners said about Merrick Garland and his sort of denial of a floor vote. I do think, of course, that that's something that left a bad taste in Democrats' mouths and made them feel like they needed to escalate in the legal fight. But I think it's important to point out that historically, it has been common for the U.S. Senate to deny president's appointments in an election year when the president is of an opposite party. And so there have been some kind of tit for tat escalations in the appointment process over the past few years. And I think Kim did a good job of laying out how those have happened. But that is a pretty long standing practice. And so I think that Democrats tried to capitalize on it when it happened, when Garland was denied the vote, as a reason to escalate in the fight over the court. But historically, that's something that both parties have done. And so I don't think you can point to that as a uniquely bad maneuver from Mitch McConnell and the Republicans in the Senate.
One last thing, too, Kyle, to your point about the court and hot button issues. A lot of this might also get better if Congress would simply do its job. One unfortunate aspect of recent politics is that over the years, Congress has decided that it's much easier to just write extremely vague statutes and leave it to the administrative state to fill in the gaps, or simply not be precise in its language, or simply not legislate at all, right? I mean, Congress doesn't seem able of doing anything but passing giant appropriations bills at the end of every year, these omnibus spending things that are thousands of pages long that nobody reads, nobody knows what's in there, because they refuse to operate on a bipartisan basis. And increasingly, there's no regular order in which committee people and policy people do the work. And that just leaves this enormous vacuum in which the courts are expected to step in and interpret things that are so vague as to be disconnected from reality. And you do get all these courts engaging in all kinds of areas where, in theory, there really shouldn't be litigation. But it's because Congress won't do the work. So we really need that branch of government to step up and start doing its job.
Thank you, Kim and Monet. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we will be back tomorrow with another edition of Potomac Watch.